rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome. I'm your host, Ron. Thank you so much for joining us today. I got somebody very special in the room today. Eddie Flores. Eddie Flores is a very well-respected prosecutor here at the Bexar County District Attorney's Office. Good afternoon, Eddie.
Good afternoon, Judge. Thank you very, very much for having me here today. I am very excited to be here.
We know why you're here, right?
Yes.
You're here to talk about grand juries. Now, let's go ahead and get it started this way. We'll go straight into it because it's such an important topic, and there's so many different things that we can talk about. Grand juries basically originate out of the Fifth Amendment of the U.S. Constitution. They are sort of like, the core of the concept of due process. Why don't you, in a nutshell, tell us what a grand jury specifically does and what their purpose is?
Basically, bottom line, a Texas grand jury is designed to hear and investigate any offenses liable for indictment. And what that means in kind of plain English is they figure out whether a crime has been committed, specifically a felony, and that there's enough evidence to meet probable cause that a person has committed a felony. And if that's the case, then they render what's called a true bill of indictment.
Let's sort of try to break down a little bit of what it is that you're saying. So the Fifth Amendment of the U.S. Constitution includes in it a comment that states, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So an infamous crime is basically considered to be a felony offense, right?
Correct.
And so what that means specifically is that district court judges don't vest as it relates to jurisdiction over a case until that case has been indicted by a grand jury.
Yes. A district court judge cannot touch any felony case until a grand jury renders an indictment on that case. Right. And that's not a guarantee. It's up to a 12 group of citizens to decide to hear that case presented to by the prosecutor and hear the evidence that has been secured by law enforcement and submitted to the district attorney's office at that point in time. And they hear the case and they privately deliberate. And if 9 out of those 12 people on that grand jury decide to come back with a true bill, meaning that they themselves believe that there's enough evidence to meet the standard of probable cause, then they return a verdict of true bill, a decision of true bill, and that case is indicted.
So although the U.S. Constitution was created over a couple of hundred years ago, the basis actually began with the Magna Carta, 1215, over 800 years ago, right? So there's a real history of grand juries and presenting juries and how the government proceeds with processing cases. So let's say there's an arrest on the street. It's got to be a felony offense. Let's just call it an aggravated robbery. Somebody goes into a convenience store, they pull out a gun, point it at a clerk, steal something, first-degree felony offense, police officer makes an arrest. What happens at that point?
Well, at that point, the police officer makes the arrest. A detective is notified, particular the robbery department, for example, if it occurs here in San Antonio, SAPD robbery, detective is the one that gets the case, is assigned the case, and is tasked with securing all the evidence in that case. Interviewing the victim, the witnesses, collecting the gun, if it happens in a convenience store, perhaps there's a surveillance video of the incident. That happens quite a bit. And so just securing the evidence, perhaps, interviewing, seeing if the defendant wants to say anything.
So a detective is assigned the case.
Yes.
They go out, they investigate.
Yes.
They gather all these documentations. Now, the person's already been arrested if they were arrested at the scene, right?
Yes.
So how does that work?
After they're arrested, they're taken to the Bexar County Jail. They go before a magistrate where they can obviously be given a bond based on the severity of the crime, the criminal history, danger to the community, but just to ensure as well that they're going to appear for any court appearance that might come down the road. As far as the case itself, after the detective collects the evidence, is finished, securing the evidence, getting all the reports of all the responding police officers that showed up, all the body worn cameras that, police that showed up have, the Coban videos that, the cameras that are mounted in each of the police officers' police cruisers, all the evidence. Then they file it with the district attorney's office.
All right. And so then this individual defendant was arrested. In Bexar County, they go to court within probably about a month, right?
Yeah.
So they go to court within a month. It's very rare that case has gone before a grand jury prior to that first court date, right?
Oh, absolutely. That's pretty rare.
All right. And the reason for that is it takes a while for the processing to go through and police officers to investigate and then provide all that to the intake section of the DA's office.
That is correct. And that's part of the division that I am part of. Since I run the grand juries here in Bexar County, I serve as the grand jury attorney for Bexar County. I help judges such as yourself, district court judges, select and train our 2 grand juries that we have going on at the same time throughout the whole year. It's not like it was before where, judges used to select the grand jurors themselves.
Right.
The pick-a-pal system.
Yeah, we basically would go out in the hallways and grab 12 people, say, come on in.
Yep.
You're going to be on a grand jury.
Yep. Those days are long gone. And so now it's done just like in any other jury selection, civil or criminal proceeding. Summonses are issued. The goal is to get a fair cross-section of our community.
Right.
That are making these very important decisions of whether to indict a person based on the evidence or not. And so they ultimately serve a big check upon the government.
So a grand jury then would be created from summoned individuals. They would come into the courtroom. Judges alternate, right? Grand juries in Bexar County last about 60 days.
2 months, yes.
Depending on the situation. Sometimes they're extended.
Correct.
Sometimes they can ask to be extended, or circumstances like COVID.
Exactly.
Yes. So there's all sorts of different things that can happen. But generally speaking, in Bexar County, they come in for 2 months. And so they come in, they're seated there. Judges give a little spiel, right? We talk about how you got to be qualified to serve on a grand jury. What are some of the qualifications that it takes for somebody to be able to be on a grand jury?
Well, for sure, you have to be a U.S. citizen and reside in Bexar County.
Right.
That is a big qualification, which actually a lot of times is one of the problematic ones because, given throughout the pandemic and just, recently, we've seen a lot of, populations shift and move. People, coming to Bexar County from other states, other counties, and people that used to live here in Bexar County, they're getting summons because they've lived here, but then they're moving to another county or a different state.
So if they were summoned and they've moved away, they no longer qualify to be on that grand jury if they no longer reside physically within the confines of Bexar County, right?
That is correct. And the idea behind that is you want people that are vested and part of this community to be making those decisions that impact our community.
So then they come in. We have to pick them, right? And it takes 16 people, generally speaking,
yes,
for us to complete a full grand jury. Why 16 if only 12 sit in on that grand jury?
So that's actually a more recent Texas law change. We need 12 serving grand jurors plus 4 alternates. And the alternates, and to be frank, we have had to use alternates pretty much every term. Mm-hmm. And I think, if I may, Judge, it's a very important point to just kind of emphasize at this point. The grand jury does not work for the district attorney's office.
Right.
They do not work for me. I do not, tell them what to do, nor any prosecutor tells them what to do. They are under one of the 10 district court judges that is presiding over them at a certain time.
And the reason why that's important, right, is because grand jurors are evaluating the part of the governmental structure that brings forth cases and determines whether or not they're going to enforce the laws and how they enforce the laws. And so being a prosecutor, prosecutors are making determinations on how to proceed with cases. So a grand jury is actually a check on what the prosecutors are doing. Is that right?
Absolutely. If you just strip away everything, the essential component of a grand jury is to serve a check upon the government, that make sure that prosecutors are not prosecuting people for improper reasons, racial, sexual orientation, political affiliation. It purely has to be based upon evidence collected by law enforcement that meets the elements of a felony offense. The decision that the grand jury is making is based solely upon evidence.
Yeah, and that really is an American creation resulting from the British common law, which started the concept of presenting or accusing juries back in the 12th and 13th centuries, when the purpose of the crown was to increase the number of criminal prosecutions and enhance the king's authority. And so when that was brought over to the United States, we had a different concept as to how that worked, right? We started looking at that as make sure that the government is doing their job.
Now, one thing I would like to point out is that being in this position as the grand jury attorney, I've heard a lot of misconceptions about grand juries. And for example, they might, I've heard, well, how can a grand jury, decide to no bill this case? That's crazy, and unlike criminal trials, petty trials, where, a person is being tried for murder or for theft or whatever felony it happens to be, grand juries are not unanimous. Their decision does not have to be unanimous. As long as you have 9 people voting to true bill the case, then the case is indicted. But if you have less than 9 people voting to true bill the case, then what happens? The presumption of innocence trumps. The default is always a no bill, right? That should be the default.
Right.
We're all presumed innocent, right? And so the default is a no bill. And it takes enough evidence to convince 9 grand jurors, at least, again, 9 strangers from a cross section of our community. We have some, that come from every part of town, that live in different parts of Bexar County, that, hold different types of jobs, that have different education backgrounds, that have different socioeconomic statuses, that are different races, obviously male and female. And so the government needs to persuade at least 9 of them to render a true bill of indictment. And if the government does it, if the prosecutor, doesn't persuade 9, then the default always is a no bill.
All right. So there's a couple of issues that you bring up. So first of all, if somebody is going before a grand jury, there's a different standard that grand juries have to look at and that are bound by that's different than juries that are listening to trials. Is that right?
That is correct.
So that's a probable cause standard, right?
Yes.
And now that's the same standard that the police use in order to make an arrest.
That is absolutely correct.
So then the question is, if the police are using probable cause or some probability that somebody committed a crime, then why does a grand jury use the same standard in order to true bill a case?
And as you know, that is what is stated in the 5th Amendment to the United States Constitution, Article 1, Section 10 of the Texas Constitution. And so that is, and the reason why it's probable cause, because again, the grand jury is serving a gatekeeping function. They're trying to figure out who to send to court to be given a trial date for whatever felony that the government is accusing them. The grand jury is basically stating to the government, you know what? We've heard enough evidence against Eddie Flores, for example, that he committed murder. You know what? There's 9 or more people voting to true bill his case. His case needs to be sent to a district court And then he needs to be given a defense attorney, or he can hire a defense attorney so that he can answer for those crimes that we indicted him for.
Now, let's say that particular case, the murder charge that you're talking about, is going before the court and is set for a jury trial. That jury that is listening to that particular case, we call that jury a petit jury. That particular jury has a different burden of proof. They have to believe that the murder was committed using a standard called proof beyond a reasonable doubt.
That is correct.
And so when they're examining their particular case and looking at the evidence that comes before them at trial, whatever the grand jury did is nothing that jury can consider as it relates to believing that somebody committed a crime, or frankly, they can't consider it as any evidence whatsoever. Is that right?
That is correct. An indictment cannot be used as positive evidence in a criminal trial that person is guilty.
It's not something that a jury can consider whatsoever when they're listening to evidence as evidence. Is that right?
That is correct.
All right. So then let's talk about the differences. And so the reason for that is because a grand jury proceeding is much different than a petit jury proceeding.
Very much different. And that's what I think since it is a secret proceeding. It is by law a secret proceeding. Most people in our community do not know how a grand jury functions or what the purpose of a grand jury is.
All right. So when you say a secret proceeding, what happens is when a judge swears in that grand jury, part of the oath is that they're not allowed to divulge any information that comes out or that comes from a grand jury discussion unless ordered to do so by a district judge.
Yes.
And that's very rare, right?
I have never seen it done in my 5 to 6 years of doing this. I've never seen a district court judge order that.
And I've never participated in anything like that as well. So when you say secret, how does that specifically work?
So what the secrecy that's enshrined in our law is any discussion of a criminal case by a prosecutor, by a witness, by a law enforcement detective, by anybody that's presenting the facts of a criminal case to a grand jury, and any discussion that is had, any questions that the grand jury asks of the prosecutor or the law enforcement detective, that is all secret, including their deliberations, how the grand jury votes, who is voting to true bill, who is voting to no bill. That is all secret. And basically everything, just picture it this way, whatever happens in that room stays in that room. And that's forever, even after the case is tried. Yes. Those grand jurors are subject to that secrecy for life.
What do you think the legal consequence would be of somebody who would exit a grand jury room and publicly state, this is what the grand jury discuss in our deliberations?
They would be subject to contempt of court and a fine and basically a punishment for stating anything that happened and that transpired in that room.
So what other factors make a grand jury different than a petit jury?
I would say it's the rule of 9. It takes 9 grand jurors to be present to conduct business, and it takes 9 grand jurors to vote true bill to return a verdict, to return a decision of indictment. Now, what happens if you only have 9 grand jurors present that day? And you have a line of prosecutors waiting to present their cases to that grand jury, then in reality, one grand juror can sink that case, can result in a no bill of that case.
One grand juror can say, I don't believe there's enough probable cause to send this case to the district court.
And that case is no billed, and that is all legal. Our law allows for that.
Would the DA's office ever be able to bring that case back to a different grand jury?
Legally, we can, yes, but our policy is not to, unless there's new evidence that comes to light. Then yes, with the permission of Joe Gonzalez and his administration, we can represent that case to another grand jury with that new evidence. But that rarely happens.
So really, it sounds like you don't want to take a case before the grand jury until you get all the evidence that the law enforcement investigatory agency can provide to you.
Yes.
And about how long does something like that take?
Well, I mean, it varies by case, but as you know, Judge, the Code of Criminal Procedure says that if the person is in custody, we, the state, the government, have to present that case to a grand jury for a felony case within 90 days.
And if the DA's office does not do that, then that individual defendant has the opportunity to come to the judge that has that case and say, we're asking you for a PR bond so the person can get released, or we're asking for a reasonable bond that they can afford so they can get released.
That's correct.
And so what happens then if somebody is out on bond already, bail has been granted, they've successfully effectuated a bond, they're outside of jail while the case is pending? How long can it take before a case is indicted to a grand jury for that case to continue to be processed in the system?
I would say, I mean, it could range from a matter of 3 months to around 6 to 8 months. Mm-hmm. It depends on the type of case. Obviously, the more serious cases, we try to really focus on those. And if the person is in custody, we kind of have to put those at the front of the line because of the 90-day rule. But otherwise, if they're not in custody, we kind of you triage based on the severity of the offense. And the smaller drug cases are there's going to be less evidence typically on those cases than, for example, an aggravated robbery.
Right. Eddie, I'm enjoying talking with you. Let's go ahead and take a short break.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
All right, we got a question from Kelly. Kelly, thanks so much for submitting your question. It reads as follows. What are my rights when I am stopped by police? What do you think, Eddie?
If it's just a regular traffic stop, which is most citizens, that's what it is. The encounter legally has to just last a very short amount of time, just enough to accomplish whatever the police officer pulled you over for. So, for example, as I have been numerously pulled over for speeding, and DPS loves to pull me over for speeding, which is fine. Hey, I admit that I do speed
if you
once in a while. Well, yes, if you do the crime, you do the time. So I know that I speed once in a while. And so, yes, they do rightfully pull me over. And so in that scenario, the police officer will tell you why they're pulling you over. And, whether it be speeding, burnt out brake light, whatever, it's usually some sort of traffic infraction, right? That detention, it's called a temporary detention. That temporary detention has to just last a very minimal amount of time, enough for just the police officer to do what he or she stopped you for. So in my case, speeding, the police officer can detain me only as long as it takes for the police officer to give me a speeding ticket or give me a warning, and then the police officer has to let me go.
And then the police officer, during that particular stop, if they can articulate some sort of belief or suspicion that there is some other crime that is happening. Let's say they believe that maybe the person is driving under the influence of drugs or alcohol, or the person is in possession of something that is illegal. Then they can investigate further. Is that right?
Yeah. That, for example, odor of if the police officer smells an odor of marijuana or drugs, then that resets that clock, and they can proceed in investigating that other drug offense, for example, vehicle.
And Kelly, if it's a pure detainer, in other words, are just investigating, they don't necessarily have to read the Miranda rights. A lot of folks think that at that particular point, Miranda rights should be given. And at any point in time, you can determine whether or not you want to answer questions, you can cooperate, you want to assert your Fifth Amendment right to remain silent, whatever evidence they gather during that particular investigation to see whether or not they want to proceed with going further in that. Of course, once you're arrested or a person is arrested, then that's when a different set of rights come into play.
Yeah.
But thanks for the question, Kelly.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back to Beyond the Gavel. I'm here chatting with my friend Eddie. Let's talk about current events. There's a lot going on in the world. Society is always changing. I'm always amazed with how things within the system have to change according to how society goes. Lately, we've been seeing a lot of instances of folks in law enforcement that are getting arrested. How are those kind of cases handled within the system?
So the way it is done here in Bexar County, when it comes to law enforcement, police officers doing that conduct of either shooting a person in our community and either shooting them dead, which would, typically be the crime of murder, right? That was committed by another person, or shooting that person and injuring that person where that person lives. Typically, again, that crime would be the crime of aggravated assault with a deadly weapon if committed by a regular person. Those cases go to our newly created Civil Rights Division headed by Chief Darrell Harris. And him and his team review those cases. And it is not the prosecutor that rejects those cases. Those cases are presented to a grand jury. Now, and why is that? That is to promote integrity in the system, trust in the system by the community, so that people in the community can know that those cases where a police officer, the people that we trust to help us, are helping us and doing their job. Those cases are not rejected by a prosecutor. So it can't be said that, the prosecutor is just on the same team as the police officer. Those cases are presented to the community, right, to a grand jury. So the community is the grand jury. They're the best representation of a community that we have here in our legal system. The juries, right? A grand jury, a petit jury, that is the community that speaks when they decide to no bill a case, to true bill a case, to render a verdict of not guilty, a verdict of guilty. They're a regular citizen that lives here in our community, and they know what they want for their law enforcement to do or not be doing. And so they're bringing that to bear when they're seeing these cases and seeing whether, was the officer justified in doing what he or she did? Or the officer was not justified in doing what he or she did. And so they have their voices heard when they hear those cases.
So, it's something that I've always heard that the criminal law is always based on shades of gray. There really is no black and white with any of this. And it really is up to the citizens that are involved in the process to make a determination as to where they want our particular system of justice to focus and the way those particular laws are enforced. We talked about some of the distinctions that make a grand jury different than a petit jury. What about things like it's one-sided? In other words, only the state can be present in a grand jury proceeding. The defense doesn't really have a right to be present. Is that right?
That is correct. And that is not my rule. That is not the Joe Gonzalez's rule. That is in the law. That is in our Texas Code of Criminal Procedure in chapter, I believe, 19, that it states that who can be present to address a grand jury.
So in other words, the grand jury is telling the state, the prosecutors and law enforcement, prove that this case should actually be a part of the court system.
Correct.
And then so in doing that, the grand jury could also subpoena witnesses and have people come in and testify in front of them. Is that right?
Yes. No, grand juries have tremendous powers. I basically tell them when I train them that they are basically 12 separate judges.
That's right.
They each have one vote, including the foreperson, whoever's the foreperson of the grand jury. They all have an equal vote. And just like in America, we all can disagree. They disagree, and they deliberate, and they argue about every particular case.
About how many cases does a grand jury indict per week?
It varies, but typically it's an average, I would say, about 200 cases a week.
All right. So that's 200 cases that go into felony district courts every week.
Yes.
There are 10 courts. So now we're talking about 20 cases that get indicted per week. And that's not counting cases that get charged, arrested, put into a court where that court doesn't quite have jurisdiction yet because it hasn't gone through the grand jury process.
That is correct. But prosecutors are mainly taking cases to the grand jury that they feel they have the evidence to prove the case beyond a reasonable doubt. As a prosecutor, my job is to basically grade the police officer's work to make sure that we have enough evidence to prove this case beyond a reasonable doubt and that they secured that evidence legally. So just taking a step back, you have law enforcement making arrests, right? Every day, day and night. You have a big chunk of cases right there. They get sent to the DA's office. The prosecutors, it lands on the prosecutor's desk. They review those cases. They're dismissing and rejecting a good chunk of that case. For example, myself, I would say I probably reject about 20% of the cases that I receive for various reasons, and I'm reviewing the case through a legal lens and doing my job as a prosecutor, evaluating the cases, also using my prosecutorial discretion. And those remaining cases that I feel that I have the enough evidence to prove the case beyond a reasonable doubt, then those cases I take to the grand jury for presentment. So you notice how that group of cases keeps getting weeded down more and more and more till you end up to the cases that are being sent to the district courts. And then those, as you know, Judge, what happens next, those cases, are weeded out even more through plea negotiations and ultimately, if not, trial.
And that's kind of a difficult proposition, right? Because as a grand jury attorney, you basically can only take the information that the police provide to you.
Yes.
So it's not until that case is actually going to court and that attorney is getting ready for a jury trial that maybe there's a different viewpoint as to how that evidence comes across in real life as opposed to how it looks on paper.
Yes, no, and that's absolutely correct. I have had cases where on paper, the report, the victim or the witness statement, it looks really, really good. But then after indictment, when you actually bring in that witness or that victim and talk to him or her in person, it doesn't line up with what is on the paper. Or perhaps they don't just remember and it was wrong. And so that does happen. And that's how does the state prove criminal cases? It's not through paper, not through those statements. It's going to be through the live testimony of those actual witnesses from the witness stand. And so that is where the so-called rubber meets the road. Mm-hmm. And that's what the jury sees to see whether a case is proved beyond a reasonable doubt.
Which is important, I think, because sometimes when the media reports on certain cases, what they do is they say, this person was alleged to have done blank as related in the police report. So then people are thinking, all right, this is what this person did. But when the rubber meets the road, as you say, and the trial prosecutors then pick up those cases and actually interview witnesses themselves and prepare for those trials, they may find something that's inherently weak in that case that would make it very different than how it's reported in the media that has just taken police statements and reports.
Absolutely. And one of the more common things is, for example, the victim that night, that defendant was arrested, provided a statement. And that's pretty common in family violence cases, as you know, Judge. They provide a statement, and then over, time passes, case is indicted, more time passes, that case is set for trial. Finally, it goes to trial, and what? We can't find the victim. Right? The state cannot find the victim, or the victim is uncooperative. Again, can I use that piece of paper as positive evidence to convict this defendant of whatever he or she is accused of doing? I cannot. I have to call that victim to the stand, and he or she has to verbally tell the jury, trial jury, what happened. And that's one of the more common examples of when, the case might have been indicted because I have the piece of paper stating enough evidence to meet those elements of that whatever particular crime. But when it comes to trial, when actually putting a live victim or witness up there, we don't have that person. That person is gone, doesn't want to cooperate, moved to a different state.
Right.
And so we cannot prove that case beyond a reasonable doubt in that instance. And that's just a more very, run-of-the-mill common incident.
In trial or petit juries oftentimes ask me after jury trials, why couldn't we get that report? Why couldn't we read whatever it was that that person said before? And the response is always a big tenet of our justice system, of the way our system of law operates, is cross-examination.
Sixth Amendment, yes.
That's a very significant part of testing the truth of what it is that people say, right?
Yes. And that is why it's very important in every criminal trial, the jury gets to see the person testify, because it's not just what they're saying, as you know, Judge, it's how they're saying it.
Right.
And so the jury is judging not only what they're saying, but their credibility. Are they telling the truth? Are they not? Whereas on a piece of paper, it's on a piece of paper. You don't know if it's a truth or a lie. But in person, at least in our system, right, that is how our system is set up to try to have the right result reached.
Now, I love talking to grand juries after they're done with their term, after their 60 days has expired. And one of the things I always ask them is, tell me what it is that surprised you. Tell me what you learned. Tell me some interesting part of the system that you got out of your experience. What are some of the things that they tell you? Because I know you develop great relationships with these grand jurors.
Yes.
And I'm always getting correspondence from them praising you, talking about the great work that you do and how well you handle them. What are some of the things that you learn from folks that go through the grand jury process? Most
of the time, I want to say out of the 12 grand jurors that serve, at least 10 or 11 don't want to leave.
Yeah, they're sorry that it's ending because the experience they got really kind of opened their eyes as to how the system works. Right?
And as you know, Judge, very few were jumping up and down at the beginning of selection to serve on the grand jury for 2 months.
Right.
Very few were were so excited that I'm going to volunteer to or be selected for grand jury selection for 2 months. Most people do not want to do that.
Right.
And they get hooked on not only hearing those cases, but actually being able to make a difference with those cases. Right. In other words, being a grand juror is, I think, it's basically kind of like the difference between everyday citizens, opening the newspaper and saying, oh, okay, we had a murder last night, we had a shooting over here. Grand jurors can actually do something about that crime. Right.
One of the things that's amusing to me that always sticks in my mind is I've had grand jurors tell me, never drive on the inside lane or the far left lane of the highway, especially at night.
Absolutely.
Why do they usually say that?
Because they've heard hundreds of criminal cases that is how the police stop that person. And it ends up being that they're found with drugs, with cocaine, methamphetamine, heroin, whatever, stolen property, whatever, or they have warrants, right? And that is how the person is arrested. And just for that little traffic violation, that is how they enter our criminal justice system.
That makes sense. One of the things that they also tell me is they're always shocked with how drug cases really pervade the system. In other words, by and large, a huge majority of cases in a felony court, the highest trial level court that exists in the state, handle drug cases, simple possession cases.
Yes. Most of the cases by far, felony cases that they hear and see are drug cases.
Now, speaking about the kind of cases that you get to see and you get to hear, you're obviously very experienced with what you do. Why don't you tell us a little bit about your history, your background, what kind of experience you have as an attorney?
Sure. I'm from Edinburgh, Texas, Judge, as you know. I still have my parents still live down there. I'm from the Rio Grande Valley. And I went to college and law school at UT Austin.
Mm-hmm.
I was there for 7 years. After that, I had the privilege of working in the district attorney's office in Wessex County,
Mm-hmm.
Corpus Christi, Texas.
When was that?
And that was from 2011 to about the end of 2014. My wife got a job here in San Antonio. And so I wanted to follow her and did follow her.
Uh-huh.
And so I applied to be a prosecutor here in the Bexar County District Attorney's Office under a newly elected District Attorney, Nico LaHood.
Mm-hmm.
Nico hired me, thankfully, and I have been here ever since.
Mm-hmm.
And now I'm fortunate to be under Joe Gonzalez's office and administration.
You obviously hold an important position, right? You work with members of the community, so you serve as a liaison, in essence, between the governmental entity that prosecutes cases and those that come in to serve on grand juries.
That is correct. That's one of the biggest hats that I wear here in my job, is being the liaison between the DA's office, the government, and the public, the community, in the form of grand juries. And I've been doing this for a while. So I have had the pleasure of meeting and getting to know, since they serve 2 months at a time.
Mm-hmm.
That is quite a time commitment. I've had the pleasure of getting to know hundreds of grand jurors. Very humbled and privileged to say that most of them, they have told me at the end that they don't want to leave.
Mm-hmm.
They want to keep on serving. They also describe their experience as a once-in-a-lifetime opportunity.
Absolutely.
You know, the first time years ago that a grand juror described it that way, it kind of made me pause, but it is true when you think about it.
Absolutely.
When you think about it, it is a once in a lifetime opportunity for just a regular citizen, a non-law enforcement person, a non-lawyer, non-judge, non-elected person, just a regular person, to have such a profound impact and be able to literally change people's lives.
They bring in their own experiences, their own beliefs, their own backgrounds. They bring in who they are as a person, and they render justice.
Yes.
That's a beautiful concept.
And that's our system.
You know, I love to eat. I think the buttons that are screaming on my shirt are testimonies to that.
Mine too.
What are some good places to eat around here?
Well, as you know, Judge, you know me, and actually a lot of attorneys in the legal community know that I am a big fiend for pollo asados.
Mm.
And so I love visiting pollo asados restaurants around here in San Antonio. I think I've tried all of them.
Uh-huh.
And so I love that food. I think it's growing more and more popular because we have more and more restaurants opening with that style of food.
Uh-huh.
And so I am a big fiend of pollos asados. There's one close to the courthouse on Culebra.
Yeah.
That you and I have visited, regularly.
And so for those individuals that need to be learned in the concept of good eat. So pollos asados is smoked chicken with very tender, very juicy. I like avocado in it.
Oh, yes.
They got the grilled onion.
Yes.
In the tortilla.
The grilled jalapeno.
The grilled with the salsa.
Yes. The green sauce and corn tortillas. And they have of course, the rice and beans with the chicharrones in it.
The best. And
so, as you know, whenever we go to lunch and we come back, we're a little sleepy, but from having such a good meal.
Hey, you can't forget the lime. You got to squeeze a little lime juice in there.
Yes. Oh, yes.
Excellent. Well, that concludes it for today's episode. Eddie, it's been a pleasure chatting with you today.
It's been my pleasure, Judge. Thanks for having me.
Absolutely. Make sure to ask those questions. Look forward to hearing from you. Thanks for listening.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.